Thank you, my Lord. Pick up where we left off. The judgment finds that the discretion enjoyed by Deckers against Up and Running in the context of Up and Running's efforts was exercised against Up and Running in the context of Up and Running's efforts to recover from the effect on its business of COVID-related restrictions. And as I noted in opening yesterday, in relation to this, Deckers makes the quite extraordinary claim, paragraph 65 of its skeleton argument, that's Core Bundle 5, page 59, that this was an irrelevant strategy with no practical effect. It was then further amplified yesterday by various other epithets, like saying that it was a niche issue. My Lord, apart from this being completely tone-deaf, given that Deckers is perfectly well aware of Up and Running's predicament with its COVID-induced bulge of stock and cash flow problems, it's simply wrong in law. Now, on the temporal aspect, this was just temporary. For brevity, I can refer the court to our skeleton argument, footnote 21, which is Core Bundle 6, page 80, and the reference there to Passmore and Moreland, which is perfectly consistent with the carte bancaire imperative of context, and which wasn't contested by Deckers yesterday. And on the one-off occurrence aspect, involving a modest proportion of trade on the relevant market, which it was alleged is simply of no importance to competition law, that's simply wrong. Deckers is arguing, in effect, that Hooker's moderate market shares mean that interbrand competition will take care of everything, praying in aid Advocate General Val to that effect at paragraph 69 of its skeleton. Well, I point out that that example given by Advocate General Val in his opinion in carte bancaire about a cartel involving players with very low market shares is a purely hypothetical, imaginary example. He was unable to substantiate that with any reference to any decided matter. He accepts that experience is relevant, but he has no relevant experience to offer on the point because there is none. Anybody
was he wrong?
Yes.
In principle?
Yes, he was wrong in principle. Because of, certainly when one is dealing with a by-object restriction, that is our submission. He's wrong in principle and he's wrong in practice, because anybody who's had any experience of public enforcement against cartels will have heard the refrain from participants that their role had no effect because they only had a tiny market share and therefore their participation didn't.
Why is it wrong in principle? Assume you've got two sweet shops who decide to rig the price of Mars bars.
Yes.
And that's a price-fixing agreement of a horizontal nature. Ludicrously small market shares. Supermarket next door that sells Mars bars at low prices. Why do the competition authorities care?
Well, as a matter of practicality, I'll accept that they probably wouldn't care. But if you want to test the proposition as a matter of law, then that low market share doesn't help. I think I need to go back to Ping, which is in the first volume of Authorities, tab 11, at page 406, and pick up Judgment of Lady Justice Rose in paragraph 111, under the heading Seriousness and Likelihood of Harm, where she's dealing with Ping's challenge to the finding by the CAT that the internet policy had a real non-offensible potential capacity to restrict competition, and then refers in that respect to Allianz Hungaria, and quoting that judgment, paragraph 38, where the court said that it's already held that in order for the agreement to have an anti-competitive object, it's sufficient that it has the potential to have a negative impact on competition. That's to say, to be capable, in an individual case, of resulting in the prevention, restriction or distortion of competition within the internal market. Whether and to what extent such an effect results can only be of relevance for determining the amount of any fine or any damages. And then quotes further aspects of the judgment. In particular, you see at paragraph 113, we're over the page on 407, that the court in Allianz Hungaria answered the question saying that it required a concrete and individual examination, but with respect to paragraph 38 of the judgment that I just read out, in paragraph 115, perhaps we better say paragraph 114, Lady Justice Rose says the question raised by this part of Ping's appeal is whether the Court of Justice was saying anything about the standard of proof, where it referred to the agreement being capable of resulting in the prevention, restriction or distortion of competition, or in paragraph 48 where it referred to competition on the relevant market being eliminated or seriously weakened. And goes on to say, in my judgment, it was not. Paragraph 38 is simply confirming the point that where a restriction is a restriction by object, there is no need to consider the effects of the agreement, the point I have been emphasising, and goes on to say the court was not laying down a requirement that a restriction is only an infringement by object if it will lead to the elimination or serious weakening of competition on the relevant market. None of the cases in which object restrictions have been found to exist refer to the need to establish a substantial weakening or elimination of competition. To set the threshold for object restrictions so high, even if only for vertical agreements, would be inconsistent with the application of Article 1011, which does not depend on market power of the undertakings concerned. I note that the Court of Justice concluded by confirming that it must be apparent that the restrictions are by their very nature injurious to competition. So, and further to our skeleton, paragraph 30.
Do you accept that, just so we're clear as to your submission on the standard of proof,
yes,
the Court of Appeal articulated, I think, what was the obiter out of this bit of this judgment. The CAT correctly recorded at 143 that the conclusion of the CMA was that the ISP revealed a sufficient degree of harm,
yes,
not just that a sufficient degree of harm was a likely or non-fanciful consequence. And the basic question is, does the agreement reveal a sufficient degree of harm to be considered a restriction by object?
yes.
So the court is saying, to put it at 115 is, it's too high to say that you've got to establish an elimination,
Yes.
or a serious restriction, weakening. That's too high a threshold. But it's not enough to say a sufficient degree of harm was a likely or non-fanciful consequence. That's too low. The in-between is the bit above. Is that a fair reading of the judgment?
Yes, the point I extract from this is it's not so much a matter of the evidential threshold for establishing that the restriction reveals serious harm to competition, but the relevance in establishing that of market shares. And it's clearly stated at paragraph 115 that is not a relevant consideration. As I submitted this morning, we're concerned with competition as a concept without regard to the particular effects it might or might not have on a particular group of consumers or other undertakings. It can reveal a sufficient degree of harm to competition, even if it only concerns market players with small market shares.
So you construe this as the Court of Appeal saying that market share is irrelevant?
My lord, yes, and I can further support
The word does not depend doesn't necessarily mean irrelevant. It means it's not determinative in and of itself.
Well,
Probably shouldn't use that term in and of itself, but not
yeah.
determinative, but it doesn't say it's irrelevant, does it?
Well, it says that application of Article 101 does not depend on market power of the undertakings concerned. The natural reading of that is that one does not have to have regard to the market power of the undertakings concerned in order to find a restriction.
What I don't understand, and I'm sorry at the moment, is that if you look at paragraph 48 of the Allianz Hungaria case, which is quoted between B and C,
Yes.
the point that Justice Green made earlier this morning, it said in order to determine the likelihood of such a result, the court should in particular take into consideration the structure of the market, the existence of alternative distribution channels and their respective importance, and the market power of the companies concerned. In what world does not market share, why isn't it relevant to that approach? I mean, the Court of Appeal wasn't saying that was wrong or trying to interpret that differently.
Well, I rest on what is said in paragraph 115, which is a binding authority of the Court of Appeal.
Well, I mean, it may be binding authority of the Court of Appeal, subject to the note, which I think everybody's provided about what we are bound with. I'm not sure, but even before the sentence, in the middle of 115, there's the reference to paragraph 48 of Allianz Hungaria, and it didn't say, but by the way, it's wrong, or suggest that it doesn't mean what it says.
Well, the reading given is that the court in paragraph 48 of Allianz Hungaria was not laying down a requirement that there be the elimination or serious weakening of competition, and even if we simply stop there, that again already puts into question the relevance of market shares. I take your Lordship's point that market power is referred to in paragraph 48, but the interpretation given to Allianz Hungaria in paragraph 115 of Ping makes it very clear that market power is not a necessary condition for finding a restriction by object. If you have market power, you will be in a position to inflict a substantial weakening, at least, of competition on the market. And yet it said there's no need to do that. But there is another reason why.
Can I just ask what, if you're right, why? I mean, whenever competition lawyers look at impact on competition, whether actual or potential, we always look at market structure, concentration levels, which implicitly requires an analysis of market shares and relative market shares. Why would we not? Why would you not do that? Since it's so elemental to almost every analysis of market effects.
Well, my lord, if one takes the classic example of a by-object restriction, a cartel, there's no analysis in cartel decisions of market structure. It might be brought into play when it comes to the final part of the decision determining the fine, assessing the seriousness of the infringement. If a cartel has involved the participation of players who represent, let's say, 70 or 80% of the market, then certainly in European Commission practice that's likely to be treated as an aggravating factor because it covers so much of the market. But it's not a factor in terms of finding an infringement.
So your position therefore has to be that it is quite irrelevant in an object case.
My lord, yes, but and that's not the only reason for saying so. And I should come to the second.
Then if you take that out of economic and legal context,
yes,
what are you left with? It's so normal that we look at market shares
Yes.
because it's an incident of looking at levels of concentration, market structure, you name it. It is part and parcel of something which is integral. Once you strip that out, what are you left with?
Well, if you're looking at a case like carte bancaire, which is a very complex agreement involving two-sided markets, yes, take your lordship's point. But on the other hand, if you're looking at something rather more banal and where there's a path very well trodden through many, many decisions, such as RPM, then, as I took you to this morning, there are, for example, the CMA decisions, there's CMA guidance, there's European Commission guidance to the effect that restrictions like that are almost always going to be condemned as by-object restrictions.
So carte bancaire, which was a horizontal agreement between, I think, every major bank in France, about 150 of them, including Paribas, SocGen, you name it.
Yeah.
That horizontal agreement which transferred costs and increased costs on new entrants, that does require some sort of economic analysis, including market share, but something like a restraint on price, let's not worry about whether it's labelled RPM or something else, by someone with 3 or 4% of the market does.
Yes, well, my lord,
Not turning it the wrong way round.
Well, I go back to the recent cases which the court directed us to pay attention to, which I took you to this morning. Notably, Tondela, the opinion in Tondela, where
the Advocate General says you assume formalism. You look at economic context.
There is a traditional line of analysis where there's a category of agreements known to be harmful, and you find the same thing in the judgment in the Banco B.
Okay, all right. Let's assume you're right. Do you then categorise this as hardcore RPM? Yes.
Well, RPM is hardcore.
Okay. Well, so that's so you say the moment you categorise it as RPM, it is hardcore. It is therefore, according to decisional practice, of such a nature that it must be treated as having an object. Is that it really?
My lord, yes, and the practice is in accordance with that, and the guidance that's been issued is in accordance with that, and more pertinently for present purposes, Decker's acted in accordance with that at the trial. I think I need to take you to day one.
Can I just ask whether you're pursuing the point that it's hardcore because it's in the block exemption?
Well, the point I'm about to make doesn't depend on the very word hardcore. It's about whether it being by object.
Okay. Do you accept the tribunal was incorrect to rely upon the block exemption in the light of Pierre Fabre, which sort of, I think, says the opposite? Was it Banco?
Well, no, it was
Superboc.
Superboc says that you are entitled to rely on the block exemption.
I think it says the opposite, doesn't it? It says there are no, simply because it's in the block exemption, you must not treat it as either presumed or deemed to be a restriction of any sort, nor does it forgive you the need to...
Well, let us go to Superboc. I think that needs to be clarified.
Superboc paragraphs 40, 41 and 42.
Well, the point I was going to draw your lordship's attention to is, if you're there on page 1190, paragraphs 37 and 38. So 37 is where it recites the standard test for whether there is a restriction by object, sufficient degree of harm.
35.
And, yes, well, those are the carte bancaire considerations.
Necessary to take account of actual conditions, functioning, structure
Yes.
of the market.
Yes, but it also says that when the court on the remittal of the case makes its assessment of whether, having regard to those carbon care criteria, there is a restriction by object. When it makes that assessment, the referring court must also take into account the fact, which it has itself pointed to, that a vertical agreement fixing minimum resale prices may fall into the category of hardcore restrictions.
May. Doesn't say does. It then goes on and says you must carry out an economic analysis.
Well, if it is RPM, I am puzzled by the reference to may in paragraph 38, because if it is RPM, then very clearly it is a hardcore restriction. But it's certainly not saying that a court
even
is
if
not
it is, I mean, we get
into consideration.
carried away with labels. They then go on to say, from there till 42, you've got to carry out an analysis of effects. If it was hardcore and it was per se, why would they be saying that?
Well, that's going back to the question of whether the restriction is to be characterised as a restriction by object. But if it has been characterised as a restriction by object and it's RPM, then then it would be a hardcore restriction.
Okay, 42. It follows the referring court cannot dispense with carrying out the assessment carried out in para 37. And para 37 makes it clear that you've got to establish a sufficient degree of harm to competition.
Yes.
In light of the criteria referred to at 35 and 36.
Yeah.
Yes.
35 of which directs you specifically to look at the actual conditions of the functioning and structure of the market or markets in question.
Yes, but one of the things that you are injuncted to take account of is the fact that RPM is, they say may, within the category of hardcore restrictions.
What does that mean? I mean, you've already got the point that if it's a RPM, in the sense that we've been seeing in the cases where there's an actual agreement not to sell at below a minimum price, if it is that, then you've got your point that experience and that part of the test shows us that that's generally considered to be by object, and therefore the economic and legal context analysis is less intense. What does it add to that? Say, oh, it's also a hardcore restriction.
Well, it's a corroborating factor that here we have a by-object restriction. We were taken yesterday to the block exemption regulations, 2010 block exemption regulation that's relevant here, and the recitals to that describe, of course, what the regulation is doing. This is in Authorities Bundle 1. And it's tab. No, so, I'm sorry. No, it isn't Authorities. It's tab 3. And yes, if you turn to page 27, tab 3, volume 1, you'll see recital 10. This regulation should not exempt vertical agreements containing restrictions which are likely to restrict competition and harm consumers, or which are not indispensable to the attainment of efficiency-enhancing effects.
Sorry, I've lost the page.
Oh, I'm sorry, it's page 27 of volume 1 of the Authorities.
27 will do, thanks.
Down near the bottom on the left-hand side, and recital 10 goes on to say, vertical agreements containing certain types of severe restrictions of competition, such as minimum and fixed resale prices, as well as certain types of territorial protection, should be excluded from the benefit of the block exemption, irrespective of the market share of the undertakings concerned. And that, irrespective of the market share of the undertakings concerned, that's reflected in the de minimis doctrine, which doesn't include restrictions by object. As ever, I want to impress upon the court what actually happened before the tribunal and what the tribunal had to deal with. As any criticism of the judgment which doesn't take account of that is misguided. And could I therefore take you to day one of the hearing? That's the supplementary bundle, tab 21, at page 272. I think we can pick it up there, where Mr. Tidswell is trying to see what the framework of the argument is. And so he says at line 3 on page 272, I'm just making sure I understand your argument. We get to the point where you say it's an object restriction. It's hardcore. Then as a result of that, the vertical block exemptions don't apply. So they're just gone. And I think there is the de minimis notice floating around. So he seeks the clarification of what Decker's position is on this. And then at line 12, Disparage says, yes, the de minimis notice won't apply if this is run as an object case, which we understand it to be. So assuming that, and again it's helpful you asked that earlier, assuming that, then no, we don't rely on the de minimis notice and we can leave that to one side. So that, my lords, is an answer as to why there isn't a consideration of market shares in the findings made in the judgment. It all goes back to...
well, they conclude that they're unlikely to be significant, don't they, on market shares.
And now here on appeal, Deckers has relied on the Commission's 2010 guidelines to try to counter that. For the sake of brevity, that's already answered in our skeleton argument at paragraph 30, and you were taken to that yesterday by Ms. Dimitri. But for the sake of completeness, and since this does seem to be a rather important point in the case, I think we should go back to that. Although I think the point, I'm sorry, my lords, that point I have already made, where I've explained the context of Chapter 6 of the Commission's guidelines by drawing attention to what's at 96, which refers to the enforcement policy in individual cases, the framework of analysis, and it stresses that it doesn't apply where there are restrictions of competition by object. And so all of those subsequent passages talking about the market position of the parties, it doesn't apply to those. That you already have that point. Then Deckers tries to improve its position by coming back on the issue in its observations on the CMA's intervention, realises the Commission's guidelines don't help. So it turns to the CMA. Well, the CMA's vertical block exemption with guidance of 2022 bears a remarkable resemblance to the Commission's guidelines, and it's of no more assistance to them there as the Commission's guidelines are. If we just briefly go to the CMA guidance, that's in the authorities volume 6, tab 36, and at the very beginning, paragraph 1.4, your lordships were already taken to this. This is tab 36 at page 2182. It says vertical agreements do not generally give rise to competition concerns, and generally is of course the operative word. And then if we turn on to page 2191, vertical agreements which generally fall outside the scope of the Chapter I Prohibition.
Sorry,
Then-
can you give me that?
I'm sorry, I
I just didn't catch it.
page 2191 in tab 36.
Yep.
And if we go over the page to 2192, then it says, unless, 4.6 at the top, unless an agreement has the object of restricting competition, or is part of a network of parallel agreements, cumulative effects, vertical agreements entered into by non-competing undertakings whose individual market share in the relevant market does not exceed 15% are generally considered not to have an appreciable effect on competition and therefore to fall outside the scope of the Chapter I Prohibition. So that's reflective of the de minimis doctrine. And so the market power issue, I submit, one is legally wrong, and secondly, that Decker's correctly made the concession that we did before the CAT. My lords, I'll have to be brief on my remaining submissions. I just mentioned that the reliance on CABO concepts and a case that's cited in CABO, seafood and my fish, these are completely different facts. There's no selective distribution system there. We could very briefly go to CABO, as there is mention there of market power, and that's in volume 2 at tab 14. And so if we go to page 540, under the heading anti-competitive object or effect, then you see the argument that CABO says the agreements were anti-competitive by object because their entire purpose was to exclude CABO from the market. And then there is some discussion about market power. Over to page 541, paragraph 381, where Mrs. Justice Bacon says that in the present case the transparent purpose of the agreements was to exclude worldies from the market. And she goes on to explain that it was able to do this through the significant market power which it wielded, which meant that the key retailers had little choice but to accede to MGA's demands, albeit in the case of the entertainer very reluctantly. But the factual background here is, as I say, there's no pre-existing selective distribution system. The market power was relevant because it explained why MGA was able to negotiate these agreements, which were ad hoc agreements, with these retailers. Now here, Up and Running is operating on the standard terms of Decker's. It was take it or leave it. If it wanted Hoka shoes, it had to abide by Decker's terms of business. So this all takes place, in our case, takes place within the context of the selective distribution system. So I say that CABO is very different. It's a different type of agreement. It's a completely different configuration, and it doesn't assist. So if we take, in other words, this carte bancaire holy trinity of content, objective aim, and legal and economic context, then we submit there's very little left in the appeal. The content of clause 15 is not in doubt. There's not much there, except the complete discretion which Decker's enjoys. The objective aim, now here there seems to be some doubt still about which factual findings might still be in issue, but if they include, for example...
I can assure you for our part, we'll just read the judgment,
yes.
work out what they said, what they find, and go with it.
I'm grateful, my lord. But if we take passages such as passages drawn to my attention by my Lord Justice Zacaroli, paragraphs 181 to 183, well, if those are contested, then, well, you have our submissions based on Henderson and Foxworth investments that any challenge that's been mounted by debtors to those findings falls way, way below that standard. So, my lords, before I conclude, I should just, though, make a few submissions about the finding of a restriction by object. That what the tribunal found were restrictions that were sufficiently harmful to competition. Now, there are two. There's the online sales restriction and the RPM restriction. And the online sales restriction is introduced in paragraph 163 of the judgment as restricting up-and-running's ability to make effective use of the internet. And that's found in paragraph 213 to be a restriction on passive sales to consumers. Now, it's useful here to refer to the CMA's guidance again, which, as I say, is very, very similar to the Commission's. But perhaps before I go there, I should go to the legislation, the 2022 legislation, which is not temporally applicable, but in terms of telling us what current law thinks about restrictions on internet selling, it's instructive to see what it says. That's in the first volume of the authorities. It's volume 1, tab 2, page 16. You have there in Article 8 a definition of hardcore restrictions, and a hardcore restriction, subparagraph 2, is one where one or more provisions, directly or indirectly, in isolation or in combination with other factors, have as their object, and then we're interested in little c, where the supplier operates the selective distribution system, and then going to little 3 over the next page, 17, the restriction of active sales or passive sales to end users by members of the selective distribution system. And as to what might be a restriction on active or passive sales, then over the page, again, page 18, in subparagraph 6, it defines further what is a restriction on active sales or passive sales, and at letter A, the prevention of buyers or their customers effectively using the internet for the purposes of selling their goods or services online.
Can you help us? We understand that point. Can you help us with this? That Mr. Mitriou says that that's far, far too large a sledgehammer to crack a nut, because there was no restriction on use of the internet. There was, they accept, a restriction on the use of the unbranded internet on these facts. So it's a yes and a no. She also points out that in the block exemption and in case law, you can have a restriction on different types of outlet to protect the system. So you could say, bricks and mortar, you have a posh outlet on the high street, you can't have a back street store or a market store.
Yes.
So it's not quite as naked as saying there was a ban on internet sales. There was and there wasn't here. And the wasn't is relatively limited because it's linked only to anonymised internet. So it's not a clean case such as we had in Ping, for example, which was a prohibition across the 2,000 odd outlets across the whole of the UK. It's quite different.
Well,
Or do you say it doesn't matter, it's never a question of degree?
Well, it is a question of degree if one follows the 2022 order, because it talks about effective use of the internet. And I just refer that you needn't turn it up, but I took you this morning to a CMA decision, DAR lighting, and paragraph 4261, page 1940, discussing that RPM can be indirect. Again, uses the VBER definition of a restriction on ability to determine retail prices. And that brings to mind the discussion that your Lordship had with Mr. Dimitriou yesterday about the meaning of that word ability.
Yeah, no, I agree.
And Mr. Dimitriou said that ability was the key word, and I would submit that ability is it's not a contractual word. The suggestion being advanced against me was that unless there was some kind of black and white restriction in Decker's terms and conditions that prevented the use of the internet in a certain situation, then that situation couldn't be specified as couldn't be found as a restriction by object. And I submit that, in fact, both the legislation and the practice shows that it's much wider than that. Now, your Lordship just mentioned to me the parallel of the ability to control bricks and mortar shops, but let's just go back to what CMA says about that. So this is in the CMA guidance, which you've just been to. It's in Authorities Bundle 6, tab 36. And I'd just like to briefly take you then to paragraph 865, which is at page 2251. And that explains that there's an exception to the hardcore restriction, allowing a supplier to restrict the place of establishment of its authorised distributors. This means the supplier may require its authorised distributors to restrict their distribution outlets and warehouses to a particular address, place, or geographical area. However, it then goes on to say that the establishment and use of an online store by an authorised distributor is not equivalent to the opening of a new physical outlet and may not be restricted. So I would submit that parallel that your Lordship draws with the physical outlet is certainly not the view of the world of the CMA.
I mean, I get that if it's you can't have an online presence, as in Ping. Here you can, and it's a particular type of marginal online presence that's being, which wasn't perhaps marginal for Mr. McFarlane, but in the overall scheme of the network, it may be viewed as more marginal. There's no evidence that others want it. We understand that Mr. McFarlane was in a different situation, as you've explained.
Well,
but is that what they're really referring to here? The use of an online store. How absolute is that?
Well, let's posit that a distributor has an online store. 865 is perfectly capable of being read as meaning that if he wants to start another online store.
It could be. I mean, one's got to apply a bit of economic context to this. We have to read it purposively, don't we?
Well,
even though it's only guidelines.
Quite so, my lord, but the point is, the context here is that it's talking about a requirement for an authorisation to have an extra premises. I mean, by definition, they've probably already got one premise. So can they have another one?
So what happens if you want an online store which sells shoes and porn? Could you prevent that? Shoes and cigarettes, shoes and booze,
Well, I'd suggest that
shoes and porn, shoes and booze.
well,
Can you prevent that?
it certainly adds a new dimension to hardcore, but I'd suggest that that's going to be solved by something much less complicated than what we're concerned with here, and that's just a simple contractual restriction that you are not allowed to combine your business with something that may bring into disrepute the business of shoes or whatever it is. So I don't think that's really a competition law problem.
But on this, okay.
Going back to the legislation you first showed of the exemption itself, if it was, I'm looking at the subparagraph 6A you read out to us earlier,
Yes.
the prevention of buyers or their customers using the internet, if that's what it said, then there wouldn't be any doubt it's not engaged here with. So it all hangs on the word effectively.
Indeed.
Is there any guidance, authority, anything which tells us what the word effectively means there?
Well, that concept of using the internet effectively has I'm sorry, I'm just checking whether it's a concept that is employed in the CMA decisions I referred to. It's that legislation of 2022 is, I think, bringing legislation up into line with current thinking. You see from the CMA decisions, they certainly go in that direction in the sense that there are passages I draw your attention to which talk about the importance of online selling for consumers to find goods and for price competition. So from a consumer perspective, yes, something like what is going on here is preventing up and running from using the internet effectively.
So I may have
But
missed
there is nothing further I can really...
I think I've missed a step up there because that's not the applicable wording for us anyway. That's the 2022.
That's right. Man.
So what, the wording we're looking at is to be found where? Which page?
2010 block exemption.
It's the 2010 European Commission block exemption,
Tab 3 of
which
Oh, yes.
authorities one.
which doesn't say anything specific, even though it's 2010 and it's well after the invention of the internet. It's pre-Pierre Fabre, so it just didn't seem to be on the radar. And so there, in relation to the 2010 Commission block exemption, we are simply in the realm of Article 4C, at the bottom of page 30, tab 3, the restriction of active or passive sales.
There's no reference to the internet.
No, indeed, my lord.
10 years ago, we'd have bunged this off to Luxembourg. So, washed our hands of it for 2 years.
Quite possibly. Now, I don't think I need to take you to Ping any further, and you have my submissions in up and running skeleton argument about why the block exemption regulation cannot pronounce on whether something is a by-object restriction. There's a constitutional impediment there, the Commission. But in terms of this debate between by-object and hardcore, and the position taken by, for example, the CMA, that hardcore is not necessarily by object, just to show you how very, very limited the scope of that is, and how Lady Justice Rose's observation in Ping that hardcore restrictions like RPM are by object restrictions almost always. Let me take you back to the CMA guidance. No, in fact, I think it may be simpler to take you to the Commission's 2022 vertical block exemption guidelines. Now, again, this is the 2022, so I emphasise this is simply showing the development of thinking, but it may be informative. So this is bundle 6 at page 2366. And recital point 177 recalls that Article 4 of the block exemption regulation contains a list of hardcore restrictions, serious restrictions, which should in most cases be prohibited because of the harm that they cause to consumers. And then over the page, we find the presentation of this conundrum of the hardcore by object issue. This is page 2367. 179 says hardcore restrictions are generally restrictions of competition by object because they are harmful by their very nature to the proper functioning of normal competition. And then, consistent with the arguments made by my learned friends, paragraph 180 says, however, hardcore restrictions do not necessarily fall within the scope of Article 101.1 of the treaty. If a hardcore restriction listed in Article 4 is objectively necessary for the implementation of a particular vertical agreement, for instance, to ensure compliance with a public ban on selling dangerous substances to certain customers for reasons of health and safety, that agreement exceptionally falls outside the scope of 101. It follows that the Commission will apply the following principles when assessing a vertical agreement, and then it explains how that's going to work. So there's an extremely narrow, hypothetical, there's no example cited, instance of when a hardcore restriction might not be a restriction by object.
This was a 2022. This is inconsistent with the Commission's own submission to the court in Superbog, which was also 2022. So well, they don't cite Superbog here.
No, but my lord, I don't think the Commission is... The Commission, if I recall Superbog, the Commission says it's not necessarily. It's essentially using the same language. The timing of Superbog suggests to me that the drafting of the 2022 guidelines and the submissions made to the court in Superbog by the Commission must have been more or less coincidental. So it would be very surprising if the Commission said anything different. Also, there's no guarantee that what Superbog says the Commission submitted is the totality of what the Commission submitted. It may be a very summary statement of what the court thought it appropriate to recall. But there's no guarantee.
They cite the Commission's submission in Superbog 4041. The concept of hardcore restriction and of restriction by object are not conceptually interchangeable. Do not, I agree, necessarily overlap.
Yes.
Therefore necessary to examine restrictions falling outside that exemption on a case-by-case basis with regard to Article 101.
Well, that I would submit is perfectly consistent with...
Well, they say there's almost a presumption in 179 are generally restrictions of competition by object, which is conceptually impure, according to the Commission in Superbog. Anyway, at least we've got to read the two together, I think.
There's, just as an aside for what it's worth, there's some help on what effective means in the context of internet sales at paragraph 203 of that document.
Oh, I'm grateful, my lord. This is I'm sorry, the Commission's...
The Commission's guidance. It's obviously on the 2022 legislation that's the guidance.
Yes. And it's, I'm sorry,
Page
paragraph-
2372, paragraph 203. So particularly about 8 lines in.
Yes.
For instance, this is the case for vertical agreements which have the object of significantly diminishing the aggregate volume of online sales.
Yes. Well, this particular case, indeed, the diminishing aggregate volume of online sales was indeed of the essence of it. So I'm grateful for that further reference to what at least is thinking from a competition enforcer about what is effective use of the internet, though I recognise there's no decided authority on it. My Lords, I must conclude to allow Mr. Mitri some time. So I think the very last point on restriction of competition I would mention is that, again, for brevity, a reference to our skeleton argument, paragraph 45, about a challenge to the online sales restriction as a restriction on passive sales, where Deckers relies very heavily on Advocate General Val in Coty, and I'd again just recall our submissions at paragraphs 6 and 7 of our skeleton argument, that's core volume tab 6, page 71, where we explain that Coty is actually quite a different kind of case with a number of important distinctions to be drawn from the present case. Furthermore, Coty is very much posited on metro compliance, and that's of course now completely out of reach in these proceedings. And even Advocate General Val, whose opinion Deckers draws on, does not in 2026 necessarily provide much support for their position. First of all, Coty is a case very much about luxury selective distribution systems, a point we've emphasised in our skeleton. It's very different. It's questionable if luxury considerations are relevant here. And just to make good on a point that came up in argument about the quality of the running shoes websites, I can just demonstrate that that was certainly not an issue here. If you go to the supplementary bundle...
Is it an issue? I mean, we take the perspective as a perfectly decent, fine, unproblematic website. That wasn't the objection. Wasn't really as to quality. It was to use to sell.
Well,
price.
I'll just then give you the reference that in supplementary bundle 22, page 387, there's Mr. McFarlane's cross-examination of Mr. Hagger, where at line 16 he accepts that he never had any issues on the quality of the running shoes website. Yep. He just doggedly sticks to signposting. But just going back to Advocate General Val, his opinion in Coty, paragraph 118, this is page 957 in volume 3, tab 21 of the authorities. He very much makes it clear that he's talking about his position at this stage of the development of e-commerce. So that's about 2016, I think. And that doesn't necessarily work today. So, my Lord, I appreciate I haven't, formally speaking, embarked on ground 3, but I think in view of what's been covered and the way that hardcore restrictions have come into the debate inevitably in relation to ground 2, then there's very, very little I need say. I will only say that some rather strange results and impractical results follow if Decker's approach to hardcore restrictions is accepted. The hardcore restrictions are defined as your lordship noted yesterday, by reference to the 2010 legislation, in broad terms, the heading, first part of Article 4, talks about vertical agreements which directly or indirectly, in isolation or in combination with other factors under the control of their parties, have as their object. And it's the restriction of the buyer's ability to determine its sale price. And you have my submissions on ability, so I won't labour that. Stepping back, realistically, for a member of a selective distribution system, they can only hope, and that's already demanding and difficult, to litigate a restriction in a selective distribution system on a by-object basis. And if you think about selective distribution systems, by-object restrictions that might lead to the sort of clash that we have here, then it's overwhelmingly likely that those are going to be hardcore type of restrictions. So if, having established that there is a restriction by object, having navigated the hazards of carte bancaire and all of that, then it would be very strange if that restriction could somehow be absolved by an excessively narrow reading of the vertical block exemption regulation. The vertical block exemption regulation, recital 10, makes it very clear that hardcore restrictions are bad things, and they are for that reason excluded from the exemption. And I just glance back, figuratively speaking, to the Pierre Fabre judgment, where the court makes it clear that there is no cause to give a narrow reading to what is a hardcore restriction in the VBER, because there is always available, even if it's not available in this case, the possibility of seeking an exemption under Article 101(3).
Yes. You're entitled to be cautious, put it that way.
Yes.
Yep.
And so we submit that there's no error made by the judgment. We can take it all in the round. If we just look at paragraph 213, the court says, the tribunal says, we conclude from our review of the content, objective aim and the legal and economic context that the restriction on the entry into the clearance channel was a restriction on internet sales under the Chapter I Prohibition. And you have the same formulation at paragraph 215 for the RPM restriction, and in both cases, paragraph 214, 216, they say that these are by object restrictions because they're consistent with experience, and as the tribunal says, there's no new or unprecedented practice here. Once you look through the fog of what was going on, my lords, I should conclude, unless the court has questions for me. Those are our submissions.
Thank you very much indeed, Mr. Carter.
Thank you.
Mr. Armitage has asked if it's with the court's permission if he can make a short point.
Yes, it's not a submission. It's just one additional reference which goes to my Lord Justice Zacaroli's query about whether there's any guidance on the concept of preventing the effective use of the internet. Just to give you the reference, it's the CMA's vertical guidance, paragraph 8.41, Authority 6, tab 36, page 2244, which discusses that issue in the context of the use of restrictions on the use of online marketplaces, and then there's a similar point at paragraph 10.122 of the same guidance.
8 point.
So the first one is 8.41.
And then 10.122.
And then 10.122. It's essentially the same point with slightly different emphasis.
And the reference that my lord referred to in the Commission's guidance, which was along the lines of, something wouldn't be problematic unless it significantly diminished aggregate volume. Is that the sort of thing we're looking at? Is that also a relevant indication?
Not in relation. So this is different. This is about an instance of restricting a a buyer from using an online marketplace. And the point that is made at 8.41 is that may not be an object restriction, provided there's no prevention on the use of the supplier's own online store. Sorry, the buyer's own online store. So it's a different point, but it again goes to this question of effective use of the internet. So I just wanted to ensure you have.
Yeah, no, I understand. Yeah.
May it please your lordships, the tribunal in this case found that a purpose of the provision that it was looking at was at least in part to prevent hawker retailers discounting hawker shoes on a clearance basis in the clearance channel. It's a finding of fact of the tribunal. And on its face, that can be said to be aiming at the reduction of price competition in hawker shoes. So that's the starting point, as it were, from the tribunal's judgment. Mr.
And that
Khan's...
paragraph, just for the note, paragraph is?
The at least in part paragraph, Miss Berridge will find it for me in a second. Let me come back to that.
142, 203, 189, probably 4 or 5 others.
Bingo.
Thank you, my lord.
Pick a number out of the air.
They say it a number of times. Now, Mr. Khan's submission is that is all you need. You just need a provision where the aim is to restrict price competition. And that, we say, is an extreme position to adopt. He says, hey presto, you have an object restriction if you look at the provision and you can see that its aim is to restrict price competition. He needs to adopt that extreme position in order to salvage the tribunal's judgment, because the tribunal did not look at the economic context, did not look at market shares. And it's an extreme position, and it's wrong because it fails to adhere to the object test which has been set out in the case law, starting from carte bancaire and repeatedly applied. Now, Mr. Armitage put the point rather nicely for the CMA. He said that the flaw in Mr. Khan's submission is that he's elevating one part of the carte bancaire test, the second stage, which is ascertaining the objective of the agreement, into the determining factor, or the whole test. And he's right to say that, and that's in a nutshell why the tribunal made an error and why my learned friend's submissions are wrong in law. Because an examination of the legal and economic context is a necessary part of the object analysis. Now, my Lord Justice Snowden yesterday used the word reality check, and I'm happy to accept that as a broad description of what that stage of the analysis is there to do. I also agree with, I think, the point that Lord Justice Green made in argument, which is that there is a spectrum and it's fact-specific. And where you have a type of agreement which experience shows is by its nature liable seriously to harm competition, so horizontal price fixing, or RPM proper, then it may be that the reality check that you need to carry out at that stage of the carte bancaire analysis, the economic, the examination of the legal and economic context, is reduced as compared to an agreement where there's no experience showing that it has a sufficiently serious impact on competition. Now, in this case, our essential submission, is that the tribunal failed completely to carry out that examination of legal and economic context. And it's really curious that it did, because it looked at the expert evidence, it made findings as to market share, and then it said nothing about them in the analysis. And when you get to that part of the judgment at the end, where it's purporting to apply the carte bancaire test, and you look at the heading legal and economic context, there is absolutely nothing in that section about the structure of the market. And so we say that the tribunal erred in failing to have regard to any of these highly relevant factors. First of all, the small market shares of the parties. Now, just pausing there, my learned friend's submission on market shares was both wrong in law and circular. So he kept saying that if you have an object restriction, market share doesn't matter. And we say that's circular because you need to look at market structure, including market share, in order to determine whether there's an object restriction in the first place. So he's got it the wrong way round. And on the law, he's wrong to say that paragraph 115 of the Court of Appeal's judgment in Ping finds that market shares are irrelevant in an object context. And the court put to Mr. Khan the reasons why that's a wrong construction of the judgment, and I'm not going to, those are the submissions I would make, so I'm not going to labour that point. So first of all, low market shares. Secondly, this is not RPM, and I'm going to come back to that point in the context of the vertical block exemption. Thirdly, there is no policy in relation to price applicable to all retailers. On the contrary, the tribunal accepted as a fact that retailers are free to sell at whatever price they choose. And that's obviously an important contextual factor in determining whether or not this is an object restriction. The next point is that it is inherent in selective distribution systems to limit alternative channels for sale, for retail, outside the selective distribution system. That's an inherent part. It's almost definitional. And I'll come back to that point when I look at the VBE. The next point is that this was a one-off enforcement action as against one retailer. And moreover, the evidence showed that no other retailer had asked for another internet channel with a different name. And finally, this was a one-off issue relating to COVID. Further point, there is no indication in the judgment of the effect or likely effect on pricing at all. So there's no attempt even to tackle the question of what the price would have been on the other channel and what effect that might have had in relation to pricing generally of Hoka shoes, let alone in the market sector, effect on inter-brand competition. There is no indication in the tribunal's judgment, no attempt to grapple with the scale of the issue, which is a point that the court's made on a couple of occasions. Now, in relation to that point, my learned friend said on instruction, although this is not evidenced in the judgment, that Mr. McFarlane's recollection is that the scale was about £1 million. Now, that's not in the judgment, but we've looked in the time available, and the evidence before the tribunal was that in the COVID season, so in 2020, my client made £500,000 worth of sales of Hoka shoes to Mr. McFarlane. So that's the wholesale price. Now, if those had been sold at the recommended retail price, then the gross revenues would indeed have been £1 million. But that's the gross revenue. And of course, the purpose, the whole premise, we're told, for this other website is that there would be heavy discounting, so presumably far below the recommended retail price. So we're not talking about £1 million worth of profit. Even at RRP, it's £500,000 of gross profit, not taking account of operating costs. And then that's, of course, further reduced if indeed they would have been discounted heavily. Now, I'm not tone deaf, as Mr. Khan accused me of being. Of course, I recognise that those figures may indeed be significant to Mr. McFarlane. But that isn't the question with respect that the Court of Appeal is facing. The Court of Appeal, and what the tribunal should have done, is considered whether the scale of those sales was significant in the market. And we say that there's no evidence that they were.
The purpose behind the question was to try and understand the scale of the number of shoes relative to the total market.
Exactly. So it's not something so that's a question I agree that would be relevant to the market structure point, but it's a question which the tribunal didn't even attempt to grapple with, and that's illustrative of its overall failure to grapple with the market structure. It just wasn't considered by the tribunal, The tribunal didn't ask the question. Now, my learned friend sought to minimise the relevance of the market context. As I said, his position was extreme. He said that when it comes to object restrictions, you don't look at market shares at all, and I've explained why that's wrong. He relied in that context on two decisions of the CMA establishing resale price maintenance. Both of those decisions concerned what we would call actual, properly defined resale price maintenance. So policies which required the retailers, a whole network of retailers, to sell at or above a minimum price. But even in those decisions, which I agree with the observation made by Lord Justice Snowden, in a sense RPM is almost a breed apart because of the level of experience in the case law establishing that it's usually a restriction of competition by object. But even in RPM cases, as Superboc tells us, you still need to look at the economic context. And in those two decisions, the CMA did do that.
So you'd say it's not an absolute rule that every retail RPM thing is an infringement. It's conceptually possible it might not be, but your analysis of the economic effect can be pretty soupy.
Yes, but let me exactly.
I mean they were. I mean, it wasn't a big economic analysis. It was a paragraph or two.
Well, it was a little bit more than that, but I agree that it can be more of a sense check rather than a sort of a more detailed analysis. But can I just show you the DAR case? So let's just pick that up just to show you, because it's not detailed. But if you go to the fifth authorities bundle, tab 31, page 1967. This was part of a section that my learned friend showed you. I don't think he showed you this paragraph, so no criticism at all of him for that. But if you look at 5.35, in terms of intra-brand competition, the CMA considers that the infringements would likely have had a wider adverse effect on the market by reducing downward pressure on the retail price of the relevant products more widely. And there's then reasons why that is. So it's just not the case that the CMA says, oh, RPM, there we go, box ticked. Now, another authority that my learned friend relied on was the bank BPN case. Can we quickly pull that up again? So that's authority.
Sorry, wait.
Sorry.
Hang on. I think the point was made, and if it wasn't, I'll make it to you. This is done in the context of penalties. That paragraph was in the context of penalties, wasn't it?
Yes, that is correct. So it's done in the context of penalties. But what the CMA is doing here is drawing on its analysis. So it has.
Yeah, where did it in the main part of its decision? Where was its reference to the economic context? I thought it was really quite short.
So you can see at 1947, you can see a short reference which refers back to section 3 above. So 1947, you can see legal and economic context, overview of the lighting sector, including the goods affected by it, the conditions of the functioning and structure of the market, and the relevant legal and economic context. And I think we saw in the course of argument section 3, which set out, for example, you can see it starts at page 1752.
Yeah, I'm sure that the overview of the market is sort of generally is that the only point I think I was making to you. I think that Mr. Khan made that should be put to you is that when you get to looking at the economic context as a reality check, as it were, if you've got an RPM, then it's only a paragraph or two. I mean, that would be right. I mean, obviously, when it comes to penalties, you look at it a bit more, perhaps fully, to see what actual effect this might have had in the the market, because that might be relevant to penalties.
My lord, I agree. So I agree that where there is RPM proper, that because of the experience...
Which this is.
Not our case. But
No, this.
Yes.
Sorry, yeah, the one I'm looking
exactly.
at. So, yeah.
That was RPM proper.
Yeah.
That because of the experience that's been built up in the case law, that the examination of the legal and economic context is towards the lighter end of the spectrum. So I agree with you. Or at the light.
By the length of most of the documents that I've seen of this type, that's fairly light.
Well, at the very light end of the spectrum. I'm happy to agree with that.
On the facts that we've seen, I mean, I think one's going to be very careful about generalising. It's going to be very fact and context specific.
It can be on the facts, on the cases that we've seen.
If you're in a market which is intrinsically competitive structurally, then to establish that it is a restriction of competition, I think you need more. If you've got big disparities in market share and you've got 20% or 15% and everybody else has got 1 or 0.5%, the relative size may mean that it's much easier to exert impact. So I think it's going to be really quite fact and context specific.
Yes, my lord, I would agree with that, but I would say if I completely agree with that, but if one is seeking to generalise about categories of infringement, then one could seek to generalise by saying it's always necessary in some form, you always need the sense check, the reality check, where you have something which experience tells us is very likely to have a serious impact on competition, like horizontal price fixing or like RPM, then the nature of that inquiry is, as a general matter, lighter. So but we make 2 points by way of submission. First of all, and I'm going to come to this, we say this is not RPM, that's critical. And secondly, we say that there is nothing in the tribunal's judgment about market structure. So nothing.
But to go back to your first point, the mere fact that the market share, say 5%, is not a knockout blow. If it's an RPM case, a traditional RPM case, you can't say, well, we pass the economic, we don't fail the economic context part of the test because we have 5%, only 5% of the market.
It's not by itself a knockout blow, but I would say that with all the other factors that I've just identified, so the fact that retailers were free to price as they wanted on the main channel, the fact that this was not a policy, what one normally sees in RPM cases is some policy that's then applied to all retailers. That's not this. There was no demand from other retailers for selling in this channel. And this was a one-off COVID event. There had been no demand from up and running. So we say put all those together. Those are knockout blows. I just wanted to quickly take you to Bank BPN because my learned friend sought to make something of paragraph 48. It's at A4 tab 27. Can I just take you to 1497? So he relied on the final words of paragraph 48, ascertain that no particular circumstance is such as to rebut the presumption, etc. Again, that's another way, in a sense, of putting the reality check point. But the key point is the one put to my learned friend by Lord Justice Green, which is that here the court did look at market factors, and you see that at paragraphs 60 over the page, 58 and 59. You can see at 58 and 59 the reference to these being the main players in an oligopolistic or the very least highly concentrated market, and there are barriers to entry to that market. Now, when that point was put to my learned friend, he sought to say, oh, well, it's just a stray reference, it doesn't really matter. But actually, it's part of the dispositif of the judgment. If you go to page 1506, and you see the very short paragraph, which is the dispositif of the judgment, the court refers back to those market conditions. So it obviously thought they were important in this case. And there's no time to do this, but most of the sections after paragraph 60 are about market conditions and actually quite a minute analysis of how exchanges of some type of information interact with others in that market. Tondela, just a short point, I'm not going to turn it up. That was a no-poach agreement. So if one's applying Mr. Khan's test, which is what's the purpose of this agreement? Well, an agreement not to poach is an agreement which by its nature restricts competition. And the Advocate General found that at paragraph 53 of his opinion. He said that the economic rationale of this is anti-competitive. But he didn't stop there, and he did not stop there. He then went on to find, and it remains to see whether or not the court follows him, of course, but he went on to find that, in his opinion, this was not an object restriction, precisely because of the legal and economic context.
And he actually said in terms at 54, I know he said he didn't want to turn it up. That being said, for the reasons explained above, finding that a given agreement belongs in a category of agreements that's typically restrictive of competition is by no means the end of the analysis. The legal and economic context should be taken into consideration to verify whether there are specific circumstances that may cast doubt, or I think Lady Justice Rose would say negate, the harmful nature of the agreement in question.
My Lord, precisely so, and we place emphasis on that, because if Mr. Khan were right, he would have stopped at paragraph 53 and said, well, no poach. You can't get a more overtly and an agreement with a more overtly anti-competitive purpose than agreeing not to poach players. Now, so that's what we say about restriction of competition by object. I want to make some submissions about the vertical block exemption, because we do say that this is quintessentially a case where the agreement is exempt, and that the tribunal should just not have troubled itself with all of these factual questions about the purpose of the clause. The tribunal was wrong to find that the agreement contains the hardcore restrictions in Articles 4C and 4A. Can we turn up 4C again? I know we've just looked at it, but it's at AB1, tab 3, page 30. Now, that says in terms, the proviso is without prejudice to the possibility of prohibiting a member of the system from operating out of an unauthorised place of establishment. And we say that that is crystal clear in its wording. The definition, almost, of a selective distribution system is that the supplier lays down conditions that have to be complied with by retailers in order to be authorised. And this is saying that this hardcore restriction is without prejudice to the possibility of prohibiting a member of the system from operating out of an unauthorised place of establishment.
Now, somebody said somewhere that that isn't the same as operating on the internet.
Well, Mr. Khan took you to the CMA guidelines in relation to that. But we say that he's wrong about that for the reasons essentially put to him by Lord Justice Green, that what they say is that you can't rely on this to prevent a retailer from setting up an internet sales site.
Yeah. The difference is between you can't put a block restriction on the internet in toto.
Exactly.
What you can say is you should only use a particular type of internet site or a site with a particular fascia or whatever the expression is.
Exactly so. And what does the agreement say here? The agreement says that all members of the selective distribution system are, and I'm quoting from the email, are free to sell Hocker on their own websites, which should have a domain name identical or similar to the name under which the bricks and mortar shops operate. And so we're just within that proviso. The website that Up and Running wanted to establish was an unauthorised place of establishment. Now, it's obvious why that's not a hardcore restriction. As I say, it's because it's inherent to a selective distribution system that retailers are not permitted to sell from unauthorised establishments. And that's because you're then threatening the selective distribution system, be it by reducing quality standards or be it by discounting heavily and allowing free riding on the investments made by other retailers in the system. As I say, you might say that it's a definitional requirement. And what the tribunal should have done is looked at the clause and determined that it fell within the proviso and so could not be a hardcore restriction under Article 5C. The vertical block exemption does not require competition authorities or courts to investigate the purpose of a clause or how it's enforced in particular circumstances. That would be the wrong approach because it would undermine a central rationale for the regulation, which is that it's easy to apply and that it promotes legal certainty. Can I just show you what the Advocate General said about that in Coty? So, Authorities Bundle 3, tab 21, page 959. And you can see at the top of the page, paragraphs 130 to 132. I don't think we've been to them yet. Apologies if we have. But it's appropriate that the exceptions to the block exemption, so here they were looking at 4B and 4C, be easily identifiable and therefore not dependent on a detailed analysis of market conditions and restrictive effects. You're just looking at the clause. In effect, it must not be overlooked that the objective pursued by the exemption lies in the need to allow the undertakings concerned to assess for themselves the compatibility of their conduct with the competition rules. And the pursuit of that objective would be undermined if those undertakings were required to conduct a sophisticated and thorough examination of the restrictive effects of those measures on competition, etc. Now, if the wording...
AG paragraph...
130 to 132, my lord. Now, if the wording of Article 5C itself were not enough, we have the court's decision in Coty, and as this court has seen, the court held that the requirement imposed by Coty in that case, namely that retailers' websites must constitute a storefront of their main bricks and mortar store, and that they could not sell on third-party sites such as Amazon, court held that that did fall within the block exemption. So that was not a hardcore restriction. And just looking at the,
That's paragraph 67
paragraph
68.
68 is the key one, where the court said that even if it restricts a specific kind of internet sale, the prohibition was not a hardcore restriction within either Article 4B or 4C. And we say that this case is precisely on point. And my learned friend's attempts to distinguish it in his skeleton argument and orally just now are wrong. His essential point of distinction is that that was a Metro-compliant selective distribution system. And it was, but we're not relying on those parts of the judgment that concern Metro compliance. We're relying on the parts of the judgment that concern the interpretation and application of the vertical block exemption. So that's not a good point of distinction.
The other point of distinction was that in this case, there's competition between deckers and the retailers, whereas there wasn't in Coty.
Well, that's not any point of distinction that has any support either in the block exemption itself or in Coty or in the case law. So my learned friends pointed to no case that establishes that the approach is different in the circumstances where the supplier is also competing in the market, which is frequently the case. Now, there was reference made to the CMA's, to the UK's 2022 order and reference to effective use of the internet. And Mr. Armitage took you to what the CMA said about that. Can I just take you, and I think Lord Justice Zacaroli was on to this, but can I just take you to the EU 2022 guidelines, which of course are not directly applicable because they post-date, but they are nonetheless interesting to look at. So that's Authorities Bundle 6, tab 37. And if we can take it from page 237, I think 2372 was the paragraph or the recital that my lord pointed to. Can I also show you, you've seen that, can I show you, pausing there, on the question about aggregate volumes, of course there's no analysis of that. So if that were going to be the reason why why this is a hardcore restriction, there would have to be an analysis of whether it really mattered. And we say it plainly didn't because it was a time-limited issue. And then over the page 2374, recital 208, you can see here that the supplier, this sets out essentially the more up-to-date guidance in relation to the later EU block exemption of what can and can't be done. And you can see the words in the middle of that indirectly have the object of preventing the effective use of the internet. And so in the EU guidelines, they've picked up on that language.
Sorry, it's 208, you said.
208, exactly.
Just give me a second.
So it's page 2374.
Yeah, I've got it. I'm just trying to catch up with where you are.
So sorry. So let's start from the beginning of that paragraph. So that says positively that the supplier can impose requirements on the buyer relating to the manner in which the contract goods or services are to be sold online.
Got it.
And so you can have quality standards, generally benefit from exemption, provided that they don't indirectly have the object of preventing the effective use of the internet. So I'm just picking up on the same language. And then what you see are examples of requirements which are generally exempt. And you see that at letters A onwards.
Well, it goes on. In fact, it goes on to say online sales restrictions generally do not have such an object where the buyer remains free to operate its own online store.
Exactly.
And to advertise online.
Exactly.
In
Sorry,
such cases, the buyer is not prevented from making effective use of the internet to sell the contract goods or services.
Exactly. Sorry, that was the relevant part I wanted to take you to, and I just missed it. But that's exactly it. So it's again, it's not effective use. Doesn't mean any use or any use that might allow you to sell more cheaply, or any use that might allow you to sell a bit more. It is much more restricted. And again, obviously here, there are no restrictions on retailers being free to operate their own online store or to advertise. And so there's simply nothing in these guidelines which indicates...
Both there is and there isn't. I mean, this is the unusual feature about this case. Generally, there wasn't. In the particular instance, in relation to an anonymised website, there was. So it does come down to effective. What's effective for the network as a whole?
And so what I'm saying is that even if the clause had said, let's assume that it said you cannot have a clause, you cannot have an online channel that doesn't have the name of your store, I would say that that's not a hardcore restriction, because that doesn't prevent effective use. Because of what's said here, you can see that generally online sales restrictions don't have the object of preventing effective use, where the buyer remains free to operate its own online store, which it is in this case. They're free to operate their own online store and to advertise online. Now, of course, these are the guidelines, the 2022 guidelines that apply to the more recent regulation, which was not applicable. We say even looking at these, there's no hardcore restriction. But I've taken
They cite Coty in the footnote for that proposition.
Yes, and that's
one
why
of them at least. Yeah.
That's why I say Coty's on point, because Coty is a case where the retailer wanted to sell not only on its own online store, but on a third-party website.
And Pierre Fabre.
Yes, and so what we're concerned about are absolute bans on internet selling. And that there just simply is no case that the tribunal pointed to, or that my learned friend has been able to point to, where a ban on a particular form of internet selling has been held to be a hardcore restriction or a restriction of competition by object. As I say, the closest case is Coty, and it entirely supports us. Now,
and just as I've got it, the reference, while we're looking at the footnotes there's a reference down to paragraph 224. Is it footnote 131 as it takes you to 224? Is that right?
Yeah.
And then if you go to 224, you've got the same point that you made in coming into this. And then it said the establishment and use of an online store by the distributor is not equivalent to the opening of a physical outlet, and thus cannot be restricted. Slightly ambiguous wording, but when you go to the footnote it's Pierre Fabre. It's Pierre Fabre, which means you can't stop them from having it at all. Is that right?
Exactly, because Pierre Fabre was an absolute ban. And then Coty distinguishes Pierre Fabre, and you'll remember the Court of Appeal in Ping saying PF Arbor and Coty fall each side of the permissible line, and we're the Coty side of the line, plainly. Now, we also say, and
Coty explicitly, I think in paragraph 52 or 53, says it refers to PF Arbor as being an absolute ban, and then in 67, 68 says we're different and therefore.
Exactly. It distinguishes it explicitly in the judgment. Now, going to turn to Article 4A and RPM, and I just start with Coty because Coty did not concern, of course, the application of Article 4A, but it indirectly supports our submission on Article 4A, and that's because it's obvious that by prohibiting sales on third-party sites such as Amazon, Coty was cutting off a sales channel that was likely to result in lower prices for its product. And we say that just as the tribunal found in this case, the commercial incentives of any selective distribution system member who has to invest in a brand and sell it on its main website and in its physical store will be to avoid cannibalizing its own sales by heavy discounting. That makes economic sense. Yet there was no suggestion in Coty that what was going on was RPM. On the contrary, the court held that the agreement fell outside Article 1011 altogether and was in any event exempt. Not going to turn back to it, but the Advocate General explicitly says, well, this type of clause will restrict price competition in relation to the brand, but that's outweighed by pro-competitive benefits. Now, I want to emphasise 2 points on Article 4A. The first is, really just to crystallise our submissions, the first is that it's critical to distinguish between agreements which have the object of restricting the ability of a retailer to determine its sales prices on the one hand, and on the other hand, measures which affect a retailer's incentives to price lower or which have the effect of suppressing intra-brand price competition. And that's a really critical distinction. And it's a critical distinction because many requirements, as I've said, in a selective distribution system result in a suppression of intra-brand competition. And just for your reference, without turning it back up, the paragraph of the AG in Coty that says that is paragraph 44, so page 946. And indeed, there are two sides. So maintaining the integrity of a selective distribution system and preventing preventing sales which may be cheaper outside that selective distribution system are two sides of the same coin. And you can see that in the tribunal's own reasoning. So para 167, page 211, the tribunal says, let's just turn that up. So core bundle, tab 10, page 211. The tribunal says there that the general purpose of the contractual provision is to promote the selective distribution model envisaged by Deckers by preventing the emergence of competing business models or channels for distribution. And if we stop there, that is what selective distribution systems definitionally do. You set it up and you do stop retailers selling outside them, because otherwise you end up with free riding and you harm the integrity of the business model. And then you have the sub-purposes, which are to restrict entry into the clearance channel and prevent retailers from entering the clearance channel in order to discount. But those really are the other side of the coin of promoting the selective distribution model, which is what we see in the opening words of paragraph 167. And that's why it's really important to be clear about what's meant by RPM, because if one's not careful and one includes within RPM a measure which has the effect, because of a retailer's own commercial incentives, of inhibiting price competition, entering another channel in order to discount, then one risks attacking the actual core of the selective distribution system itself. Now, we say, therefore, that that can't be the tribunal's approach to this. Can't be the touchstone for RPM, and it's also the tribunal's reasoning, tribunal's judgment is inconsistent with the wording of Article 4A itself of the regulation, which focuses on agreements with the object of restricting a buyer's ability to determine its own prices. Now, I took you to the guidelines, which are persuasive and which provide that Article 4A is concerned with agreements pursuant to which a supplier either directly or indirectly requires goods to be sold at a fixed or minimum price. You'll recall that I took you to that yesterday. And we saw that wording in the CMA's Rowland decision. Mr. Khan took you to that today, and just for your note, the reference to that is paragraph 4.162. So the CMA there referred to that wording in the same guidelines. But the same point, exactly the same point, is made in the relevant recital to the regulation itself, recital 10, which Mr. Khan just took you to. I don't know if you want to see that again. It's at tab 3 of bundle 1. Because it was put to me yesterday by Lord Justice Green, well, these are only guidelines, are they binding? And I said, no, they're persuasive, but not binding. But it is, we say, of relevance that recital 10 picks up the same language as you see in the guidance of minimum and fixed resale prices. And you see that on page 27. So if you put these points together, the wording of the provision, which talks about restricting the ability of a retailer to determine its own prices, the guidelines and the recital, and the absence of any authority identified by my learned friend or the tribunal, which supports the approach of the tribunal. The approach being that one can take account of the retailer's own commercial incentives and likelihood of it pricing, discounting, in circumstances where there's a finding of fact that contractually retailers can price as they want. That's a finding of fact. There's no authority at all to support that being RPM. We say that the case is overwhelmingly in our favour. And I have a second point on Article 4A. It applies to agreements, vertical agreements. So it's an agreement one must look at, nothing more and nothing less. And the agreement here is clause 15, read with the email. That says nothing about price at all. Now, I'm not saying that it's not open to a court to find that an agreement is not written down, that there's an understanding between the parties that's not recorded in writing. But there does have to be an agreement or understanding amounting to a concerted practice in relation that restricts a buyer's ability to price. It's not enough for there to be a unilateral act.
That might, that might be said to go a bit far when the opening words are agreements in isolation or in combination with other factors.
And Article 1.1a, vertical agreement means an agreement or concerted practice.
Yes, and I agree that it can be, that there has to be, so just dealing first with my Lord Justice Zacaroli's point, there has to be an agreement or concerted practice, obviously, for the Chapter I Prohibition to apply at all. And it has to be the agreement or concerted practice that offends competition. So you can't say, well, there's an agreement here that only does this much, but I'm going to look at other factors. And that altogether results in a restriction of competition. It has to be the agreement or concerted practice that restricts competition. And here, and there has to be a distinction between, on the one hand, an agreement or concerted practice, and on the other, a unilateral act. And I just wanted to go back to a question that my Lord Justice Green put to me yesterday, which is, what if a supplier gets whiff of a retailer starting to really discount heavily and just terminates the agreement? That's not RPM, because that's a unilateral act. So there does have to be an agreement or concerted practice.
That was the AEG point, that a unilateral act in the context of. selective distribution constitutes an agreement or concerted practice.
Well,
Or in fact, constitutes agreement, I think.
But there still has to be a concerted practice about price. So if and
It
you
leads to a
see
tacit acceptance of all the terms and conditions that go with the system.
Well,
Isn't that AEG?
the agreement here is the clause, is clause 15 and the email. So that says nothing about price. And what we have here is an instance of enforcement. And it's just really not clear that that is an agreement pursuant to which the parties are concerting not to price.
You haven't said that with your normal certainty. You said it's not clear.
No, well, it's just not. It's not
That's
tackled.
very equivocal.
It's not tackled. It's not. I should have been more forceful. It's not tackled. It's not addressed by the tribunal. So they don't grapple. They just assume that this is an agreement.
There is an odd paragraph about tacit agreement across the. But I
and
mean, this is slightly vague there.
no evidence for that at all. And
No, that wasn't really one of the facts.
that wasn't one of the facts.
No.
And so there is just the reason I'm not being as forceful as I have been on other points is not because I think it's a bad point, but because there is no analysis by the tribunal on this point. And so its findings were that DECA's purpose, when it enforced...
I know when your heart's not in it because you begin to smile.
This is unfair. Its findings were that DECA's purpose, when it enforced the provision, was to prevent up-and-running's entry into the clearance channel. And so my submission is that that finding is not a finding that the clause properly construed was an agreement between DECA's and its retailers, or even between DECA's and up-and-running to prevent discounting.
Can I just ask you to help me with Article 4A, just
Yes.
to work through, because it contains a number of sort of sub-parts,
Yes.
which sort of are exemptions and then counter-exemptions, if you like. It says the exemption provided for in Article 2 shall not apply to vertical agreements, which directly or indirectly. So my Lord Justice Zacaroli picked up it has to be an agreement which directly or indirectly. You say that's relevant. You need to look at the actual agreement.
Yes.
And then, which directly or indirectly, in isolation or in combination with other factors under control of the parties, have as their object. And then A, the restriction of the buyer's ability to determine its sale price. So just pausing there, I think your points are, in the instant case, we don't have an agreement which, just looking at it directly or indirectly, says anything about price.
So that's my second point. My first point is that even leaving that aside, the agreement does not, if there is an agreement, it does not restrict the buyer's ability to determine its sale price.
Okay, yeah. And then it says, without prejudice to the possibility of the supplier to impose a maximum sale price or recommend a sale price. That's not our case.
No.
And then these words, provided that they do not amount to a fixed or minimum sale price as a result of pressure from or incentives offered by any of the parties.
Yes.
What's the they?
So that the maximum sale price or the recommended sale price. So you can have a recommended price. So suppliers can say to retailers, we think you should sell these shoes at £75.
Right. But then if that's right,
yes.
that does contemplate some unilateral action by the seller, doesn't it? Which amounts to, in effect, a minimum price by saying something like, well, okay, this is my recommendation. You don't have to adopt it, but if you do, then, I'll send the boys round or I'll terminate the agreement or whatever. So, I mean, you said it just can't possibly apply to any sort of unilateral action by a seller, but I'm not sure there's...
So, my lord, it's a really good question. There's quite complex case law about what's a unilateral act and what is tacit acceptance by the other party. So you can have something which looks like a unilateral act, which is tacitly accepted by the other party, and that makes it into an agreement or concerted practice. And if you look, for example, at the two CMA decisions on resale price maintenance, they're very long, and the Dar decision, for example...
We've come across, we now know that nothing the CMA does is fraud.
It's wrong. It's long for a reason, because there's a lot of factual investigation as to whether or not there's a concerted practice. So whether or not the retailer is accepting and complying with what the supplier tells it to do. And so, but the words that, just going back to this, the words that I do really emphasise here are provided they don't amount to a fixed or minimum sale price. And that's the wording that you see in the guidelines. That's what RPM's about. RPM is an agreement with the object of fixing or imposing a minimum sale price. And it can be direct or an indirect way of doing that. So a direct way of doing it would be, you must sell at £75 or we'll terminate. An indirect way of doing it, and you see that further down, might be, or you see that in the guidelines rather, might be, we will give you rebates as long as you don't go below £75.
That's the incentives.
That's the incentives. But central, the central feature of RPM is the imposition of a fixed or minimum sale price, and that's why you're restricting the ability of the retailer to sell as it wants. And that's what's not going on here. In fact, the contrary is true, because retailers are free to sell at whatever price they want. My lords, I think that's it from me. I think the only point to make by way of overall conclusion is that my learned friend said a number of times, well, it's really important that the Davids can litigate against the Goliaths, and to do that you need to make this an object restriction, because effects cases are very complex. And we say that's to look at this the wrong way round, because competition law is not there to ensure commercial fair dealing. It's not something which steps in if contract law doesn't help a party. And we say this is precisely where the tribunal's gone badly wrong here, is this is precisely the type of clause that courts should not be scrutinising. It's just a waste of court resources, because they don't cause any serious harm to competition, and they should be block exempt. So, my lords, unless you have any questions, those are our submissions in reply.
Ms. Berridge, is there anything you wish to add? No? Well, thank you all very much indeed. We will, of course, reserve judgment. We will, in the ordinary way, send the judgment to the parties. If anyone, the parties, thinks needs to see the judgment who isn't on the list of those who can see it, please let us know, and we can amend the list accordingly. When we send it out, it will be for editorial comments only. It's not an opportunity to alter or to re-argue the points. And of course, confidentiality must be retained. Can we thank everyone very, very much indeed for 2 days of fascinating discussion. We thank all of counsel for their oral and their written submissions. We know that a great deal of work is done behind counsel in preparing the case. So thank you all very much indeed.
Rise of evil.